Please be seated. Call now cause number PD-0677-22, Larry Jean Hart versus the state of Texas. You can proceed. Yeah, that's okay.
One of the problems with my age, I guess, is may it please the court, Ron Goranson, Dallas, Texas. I'm appearing for the appellant Larry Hart. The defendant was charged with capital murder. Basically, the driver who took part in drove others to an apartment complex, and it was a burglary. It went bad. It ended up becoming, the complainant was shot and died. Everybody fled the scene. Trial jury convicted the defendant of capital murder. The state did not seek the death penalty, so it was an automatic life sentence. The appellant appealed to the Dallas Court of Appeals. The decision came down 2-1 against the defendant or appellant. Rehearing was denied 2-1 also, and a motion for rehearing in bank. There were 4 dissenting justices in the denial on that, the request for rehearing. The issue is with the introduction of 2 rap videos and 4 portions of the appellant's Facebook page prejudicial. I'm asking this court to establish a rule in these types of cases where you're dealing with artistic impression, rap music specifically, but it's a broader rule that includes all types of artistic impression. Basically, it's not admissible and it can be prejudicial unless it's truthful narrative of the actual facts of the case.
Counsel, go ahead.
No, you after you.
I was just gonna say, so why do we? Let's assume that this was truthful. Does that still mean that if everything he said was ascribed to everything he says in the Facebook post or in the videos is a truthful narrative of his life? Does that mean it's not prejudicial?
No, not of his life, of the case.
Of the case.
Yeah.
Okay.
Stated differently, how far do we let prosecutors use one's own culture against them?
Well, counsel, let me ask you this: why do we need a rule? Like, why do you feel like we need a bright line rule? Why can't it just be case by case?
Well, it'll always be case by case because the facts of each case will always be different. But I think if this court establishes what I'm asking for is a bright line rule, is it at least will subject the offer, the proponents to make sure that what they're offering is a narrative of the facts of the case. And also everybody's aware of how prejudicial this type of evidence is. I cited in my brief the studies, the dissenting judge at the Court of Appeals referred to even more studies than what I quoted in my briefs. The evidence is clear that this type of evidence is extremely prejudicial.
Okay, well, that's kind of what I'm getting at. What is it about this information that makes it prejudicial? What are trial courts supposed to look at to determine how far away you've gotten from the narrative of the case or something to know that this is something that's unduly prejudicial and that the risk of undue prejudice or unfair prejudice is so great that it overwhelms the probative nature of the evidence?
Okay, how do I explain human nature? I don't know that I can do that. But what I'm suggesting is the research suggests that basically, to be blunt, that white people are threatened by the message in rap music. Okay. And that's what the studies seem to show. That it might not just be white people, it's all people are threatened by it.
I appreciate that. That raises 2 questions for me. First and foremost, though, the studies that you're relying on, were those things that were presented at the trial level? Like you're mentioning the discussion about, and I read the dissent from below. It's very thoughtful. But how much of that information that the dissent is relying on, these articles, these papers about the reaction to rap music, how much of that needed to be in the record before the trial court to make the trial court decision? Can we just rely on the fact that these papers exist, or was there some obligation on the part of the state or the defense to have presented this to the trial court to make the decision?
If you've read the opinion in the Williams case, the magistrate's opinion from the federal district in Arizona, that ended up being like a 3 or 4 day hearing with expert witnesses coming in to testify, the studies put into evidence. I don't think that's a pragmatic way of approaching this, how trial cases are tried in Texas or any place really. Is that we don't have the ability to have that type of hearing every time it comes up. But I think that what the basis of a bright line rule would do would be to make sure that the judges focus as to basically the racial implications that come in because of this type of music and how it's perceived by other people.
Okay, well, that's another point. It seems like you're affirmatively asking us to make a ruling that is race-based and come up with a rule that is race-based. Does it seem like we can do that?
Well, first off, I mean, if you're going to say that it is race-based, but that's where the prejudice is because of it. This is with reference specifically to rap music, is how extremely prejudicial it is. But I think you're ignoring reality to say, well, this is just music and the jury will consider it like that. That's not the way juries look at this type of music.
Well, I'm not asking, you're taking me wrong. I'm not saying that, I'm wondering why you feel that we can or should limit it to this one style of music. I mean, you can find examples from all sorts of music that might actually offend people, and not just white people, but people from all different races. And that if someone is a fan or listens to a lot of different types of music, the fact that they listen to a particular type of music might scare a jury.
I think in my brief, I mentioned country music, the Kingston Trio.
Right.
You could even go further. A woman quoting Lady Macbeth about killing a child. I mean, you can go into all. That's why I was asking. I used the term literary expression as opposed to just limiting to rap music. I think rap music has a higher level of prejudice than country and western, and the Kingston Trio, basically, or Johnny Cash.
But what is it? I mean, that's what I'm saying. Your point is is it just the rule is because rap music scares people? What is it about the rap music? What is it about introducing the rap, and particularly with regard to this case, that makes it so that that there would be a danger of unfair prejudice? Is it a confusion of the issues? Is it because the jurors lack context? They don't understand how to interpret what they've heard. Is it that the content of the message is so inflammatory that it makes you ascribe motivations or bad behavior from a literary work to the actual actor? What is it that trial judges are supposed to consider when determining whether something is unduly prejudicial?
All I can say is the studies show that when, there's one study in the Arizona case where the people in the study were more influenced by the fact that the case involved rap music than the fact that the person was charged with murder. And so I don't know how I can explain it other than the population at large is unfamiliar with rap music, where it came from. It's actually a social protest type of music.
I got it.
They just don't understand it. They interpret the word literally rather than figures. That's the best answer I can.
Okay.
So is it the music? Is it the music itself? Is it the music plus the video? Like, what do you, like? Let's just say in this case, the state had just played, for whatever reason, they had a recording, sound only, no video. I mean, would that have made it less prejudicial?
I think the way the videos are make it far more dangerous in the jury box. Let's put it that way. I mean, I thought about opening up by promising y'all that I wouldn't do rap or wouldn't try to sing. But
Feel free.
No, I'm kidding.
I liven things up.
I'm not.
Now
about
it's time
to
to pass the mic to you.
I don't have the talent, first off, to be able to do the quick rhyming. I mean, I'm amazed at how they do that. But the visual way they do things, I mean, the quick movements, the everybody in tank tops, and it's a visual thing that basically scares people. And they're not listening to the message. They're using other senses.
But didn't you just hit on something that the state is going to argue, that basically you say you don't have the talent to put together those words and that quickness? Isn't that exactly what the state is trying to offer this to show, is that this defendant is sophisticated enough to be able to flow, to be able to put words together, to sort of respond, that he's not some, you know, naive fellow who fell in with the wrong crowd. This is the lifestyle he's chosen. And this video and these lyrics and this music and the posting tends to reinforce that he is very much of this world, that he claims that he was just a bystander in.
I thought we were supposed to convict him for the offenses
I agree.
he's alleged to
I
commit,
agree.
not the person or the where he lives. I mean, the world that he lives in. You know,
But
so I thought-
being able to do rap does show at least some level of mental sophistication that kind of rebuts the idea that the state, or that the defense was trying to present.
I don't think that's accurate. Anybody can lip sing. I mean, that's basically what one of the videos was. It wasn't his words. He didn't make up, he didn't write the words. He was lip singing to what somebody else was doing.
Well, that brings.
Isn't Judge Newell pointing out, though, that it takes a certain level of intellectual firepower to be able to do that? Not everybody can do it. You can't do it. You just told us.
I can't dance either, but that's
You and Genesis.
The jury had far, as Judge Rishik points out in her dissent, the state had far better evidence than going into a rap video to show that his presence in front of the jury, they had a videotape of his oral statement to the police before. I think that evidence it would be. You're not injecting into the case these cultural issues. And that's what I think our point is that in effect they were trying to convict him for who he was rather than what he allegedly did. And I mean, it wasn't a whodunit. I mean, he stated he took the people over to the apartment. So that, I mean, but to say that because somebody can sing a song, that makes them have the intent to commit an offense, I don't think we want to go down that road.
But
And I think that's what we want.
But it wasn't offered. It was not offered for intent. It was offered to rebut the defensive theory.
Yeah, but look at how they used it in front of the jury.
That's a different thing than what it was offered for. That's right.
Right.
Okay.
Because what they offered it for, if they'd limited it to that and requested an instruction that this evidence is only limited to such and such.
Was there an instruction?
No.
Okay.
Neither side requested it. So, I'm kind of the school that if you're a proponent of evidence, that you're the one that should be asking it. It should be limited to what we're offering it for. But that's not what the rules are in Texas. But if you want to try to protect your case, it seems to me that's what the state should have been doing in this case. We're only offering this for this. But that's not what the question showed. They were offering to show he's a criminal generally, that he possessed a gun, that he ran a something house.
Right. If he's a Kenny Rogers fan, it's questionable whether or not he would show karaoke of him doing Kenny Rogers. The state will want to put a karaoke of him doing Islands in the Stream.
I mean, there are the references to literature. I chose to use, the Kingston Trio and Marley, but I mean, you could go any place, almost
Was a
any
limiting instruction given?
I'm sorry?
Was a limiting instruction given?
No, not at all. Again, I think,
Was it requested? Sorry to interrupt you.
No.
Okay.
I did not, I don't recall anybody requesting a limited instruction. I'm pretty sure I would have put it in my brief had somebody done it.
Right.
Yeah.
Thanks.
So, I've got 5 seconds. I don't have anything I can say that quick, so.
Same time for rebuttal?
5 minutes. for
Okay,
rebuttal.
thank you, Kim.
Thank you.
May it please the court, my name is Grace Shin, and I represent the state of Texas in this PDR. We are here today because the appellant wants this court to review an issue that was never presented to the trial court and never considered on the merits by the Court of Appeals. Appellant wants this court to reverse the judgment of the Court of Appeals based on an argument that was not preserved for appellate review. At trial, appellant objected to the rap evidence on the ground that he hadn't written the rap lyrics, or that if he had written them, there was no evidence as to how long it took him to write the lyrics. Basically, appellant was saying that this evidence was not relevant to show what the state claimed it showed.
Did he make a 403 objection?
He did. He claimed the evidence was unduly prejudicial because it glorified criminal conduct. He also claimed that the evidence was not relevant because he wasn't actually rapping in the videos, but he was merely lip syncing. So those were the extent of his objections at trial. Nothing about these objections apprised the trial court of the argument that he ended up presenting on direct appeal and the argument that he presents now before this court. And those arguments, as this court has just listened, are that rap music is different. It's a special genre that's metaphorical, but often construed by juries as autobiographical. On appeal, and in this court, he argues that the rap music has cultural aspects, and when introduced in a criminal proceeding, it has a tendency to impact a jury in a racist manner. On direct appeal, he argued that because of this rap evidence,
But
he was
counsel-
convicted.
Counsel, I mean, I appreciate that. I appreciate the idea that, and I took issue with defense or with appellant's counsel on this, that he's making an argument about some sort of specific cultural thing regarding rap that we should do. But is there an argument based on just the sheer amount of different kinds of information that was presented? Because it's a video, because there's a video of it. We're talking about there's posts on Facebook. There's also lyrics to a song. A large amount of information might have actually been unduly prejudicial because it confuses the jury. It can inflame the jury, regardless of the cultural aspects to it.
I mean, there's always a little bit of danger for prejudice, and it was actually relevant to the purpose for which the state offered it. In that sense, it was prejudicial, but not in an unfair way. And to the extent there was...
Okay, so what makes prejudice unfair?
When it has nothing to do with the guilt of the defendant, but something else that's not based on the fact of the case or the allegations.
Isn't that why he's arguing that you should draw the line at saying the lyrics and all this information goes specific to the case at hand? The fact that this guy is in a rap video with a bunch of people, and the fact that he's maybe quoting Young Thug has nothing to do with the trial.
And that wasn't the purpose for which the rap evidence was offered. Mm-hmm. It was offered because the appellant took the stand and he testified basically that he had trouble using and understanding words. He had difficulty with language.
Yeah.
He also testified that he's from a small town and he just gives rise to people because he has a kind heart and an open heart. He's friendly. That was the evidence he presented.
Okay,
he
so
basically,
counsel, how does the admission of the videos rebut his testimony that he's a friendly person? I mean, you're certainly not up here saying that anyone who lip syncs an NWA song is an unfriendly person.
No, that was
thank
just,
goodness.
It
Yeah,
wasn't
really. I'm off the hook.
Yeah.
It wasn't necessarily to show that he wasn't a friendly person. It was offered to show that he wasn't that naive about criminal subject matter.
But isn't posting? I mean, I have a 13-year-old daughter, and I don't think, knock on wood, that she's posted anything on the internet in a video manner. I mean, doesn't that kind of show his naivete that he is actually posting this stuff on the internet?
I mean, I'm not sure how that goes.
Like,
I
I
mean,
have such poor judgment that I'm going to post videos of myself singing about guns and drugs. I mean,
I mean,
doesn't that
that's
seem
a
little
separate
naive?
matter. I mean, everyone should really be careful about what they post on social media. That's public. But that's kind of a side issue. The real issue is, what did the content of what he posted show, and how is that relevant to this case?
Well, I mean, doesn't it? I mean, one argument is that it shows that he spent hours and hours rehearsing the ability to lip sync along with these songs.
I mean, that's possible, and he could have been questioned about that by his counsel if his counsel was concerned about that. So it wasn't as if the state introduced the evidence and that was it. The state cross-examined him on the evidence, and then his attorney questioned him about it. So there is room to flesh it out. And these are all valid considerations, but it's also the trial court's job to weigh these considerations. And the trial court ultimately determined that the evidence was relevant to the purpose for which it was offered. And the trial court probably considered its prejudicial effect too, but likely determined that it wasn't substantially outweighed by its probative value.
Well, how strongly does this evidence advance the theory for which it was offered?
I'm not sure how strongly it does, but it is relevant, as the Court of Appeals recognized.
Right.
Relevance is a very low bar. If it has a tendency to even make a fact more likely than not, then it's relevant. So regardless of the strength, it did show.
So 403 doesn't consider the strength or the probative strength of the evidence?
403 does consider that. It's one factor.
Right.
It's one factor.
Right.
But then there are other factors, such as the tendency to confuse a jury, how long it took to develop this evidence, and many other factors. And in this case, the facts of the case were largely undisputed. It was undisputed that his friend, little partner, asked him to drive him and some friends to his uncle's home so he could break into his uncle's home. The evidence showed that he drove his accomplices to the uncle's apartment parking lot, drove around, made sure the car was there. And this was around midnight, so a time when people would be home. And then he waited while his accomplices got out of the car, and then eventually ran back into his car, and he drove them away from the scene. He also later picked up the other two who had driven away in the victim's car. Really, the only issue was, did he understand what little partner was saying when little partner asked him to drive him so he could break into his uncle's home? And he gave wavering answers when asked about this. Right. So the videos, they showed more likely than not, when little partner asked him to drive him to his uncle's home to break into the home, more likely than not, he understood. He wasn't so lacking in language abilities that he couldn't understand the simple request.
Okay, so the videos help show that he did understand this request. If that's the case, why do we have to have a whole discussion, a side discussion about whether he's lip syncing or actually wrote the lyrics? I mean, isn't that distracting the jury from the charged offense?
Well, no. First of all, the whole argument about lip syncing that was raised by the defense at trial, I'm not entirely sure how that goes to the purpose for which the evidence was offered, but the state did offer the evidence to rebut his characterization of himself as slow and not good with words. He said, I'm not good with literature, I confuse words, I don't always understand what people are saying.
Right.
So if he did write the lyrics, well, then more likely than not, his use of words and language isn't as bad as he claims it is.
What you see, my point is that by putting this evidence in, now we have to have a whole side discussion about whether the guy wrote it, whether he was lip syncing. All those have nothing to do with whether or not he's guilty of this offense.
They don't show that he was guilty, but they go towards, he kind of opened the door by testifying about how slow he was.
Yeah, which is why it's relevant.
Which is, I'm sorry?
Which is why the evidence is relevant, because he opens the door. I get it. But I guess my point is that the 403 analysis has several factors that you weigh, and the trial judge is supposed to weigh, and so I'm trying to gather from the advocates, what is it the trial court is supposed to be looking at? What should the trial court have considered when they see this in the future? When they see someone who wants to rely on a Carrie Underwood song or something.
I mean, mainly the strength, the probative value of the evidence and weighed against its prejudicial value, unfair, against how prejudicial it is. So you're weighing those two main considerations. And in this case, yes,
And
it
the
was
time it takes
probative.
to develop the evidence.
Yes.
And, right.
I mean, it's not a scientific formula, but there are factors for the court to consider. And, courts have held that in close cases, they should presume that the evidence is more probative than prejudicial. And in this case, based on the record, for the trial court to admit this evidence over the appellant's 403 objection was not so outside the reasonable zone of disagreement that it was an abuse of discretion.
Counsel, just a few minutes ago, you mentioned the word a little prejudicial. Is that a fair wording of how prejudicial you think these videos were?
I think there was some prejudicial effect, but I also think the trial court did not abuse its discretion when it weighed the prejudicial effect against the probative value and other relevant considerations.
So you're saying it was more than a little prejudicial?
Well, I don't know how exactly to quantify, and it's not my job to quantify because we defer to the trial court under an abuse of discretion standard. The only thing we ask is, did the trial court act with reference to some guiding rules or principles? Was the trial court's action arbitrary? In this case, even if one court might disagree, even if another judge might disagree, somebody else might decide, well, what the trial court did was reasonable, because even though there is some prejudicial effect, it's not substantially outweighed by the probative value of the evidence.
And also, you mentioned the facts of the case a few minutes ago, and it took several sentences. And in my opinion, that's a really strong case. Wouldn't you agree?
Yes, it's a strong case. I mean, really the only thing was...
Very well would have got a guilty verdict without this evidence. Without these videos.
Okay.
It was strong. I've tried a lot of cases myself. That's enough to be proof beyond a reasonable doubt.
Yes, I mean, we had his recorded interview, we had surveillance videos. I mean, he basically admitted to his involvement. But, he also presented himself as slow, and there was a certain point when the trial court called a recess to ask about his competency. Whether or not that was real or feigned, I don't know, but he did create that issue. So it's possible the trial court decided, you know what, it's only fair that the state gets to also address this issue. He took the stand, he opened this door, and with the Facebook records, for instance, the state initially offered thousands of pages of records. It ultimately only used 4 pages, and each page, maybe one sentence was highlighted. So even the amount of evidence with respect to the rap wasn't substantial. It was only a fraction of the state's case. So those were all considerations that the trial court could take in its 403 analysis. And the majority of the court on appeal held that the trial court did not abuse its discretion under 403 in letting it under 403.
Counsel, how do you feel about the fact that, I mean, yes, it was 2-1, but how do you feel about the fact that even the two basically said, please don't do this?
You know what? I don't disagree. But it is an abuse of discretion standard, and based on the record before the Court of Appeals, based on the arguments that were made, based on the evidence, based on the applicable rules, the Court of Appeals did not act outside the zone of reasonable disagreement. Reasonable minds can disagree. Even on appeal, you had a 2-1 split. People disagreed. It doesn't mean the trial court abused its discretion. The trial court abuses its discretion if its ruling is outside the zone of reasonable disagreement and if it acts without reference to any guiding rules or principles. And that's just not the case here.
Well, counsel, I mean, that's, I guess, the thing that I'm concerned about, which is why I've been asking for what we are supposed to consider, or repeatedly asked what we're supposed to consider when determining whether there's undue prejudice, is that it starts to sound like to me from the arguments I've heard, the argument here is about whether this is relevant. And it seems like everyone sort of agrees that this is relevant. That's only the first part of the inquiry. And that means if they're not doing the 403 analysis, are they relying on, are they following are they making an arbitrary ruling? Are they just basing it on relevance and not doing the full 403 analysis?
First of all, I don't know if everyone agrees that the rap evidence was relevant. I believe at trial and on appeal, the argument was that the evidence was not relevant, but for different reasons. There was one reason presented at the trial court level and another reason presented at the Court of Appeals. With respect to the 403 analysis, are we reviewing the 403 analysis conducted by the Court of Appeals? I'm not sure I entirely understand.
Well, are we supposed to, what are the things that we're supposed to consider to determine whether the trial court actually did the proper 403 analysis? How do we say in the future when something like this comes up, this does or doesn't violate 403? Or doesn't run afoul of Rule 403?
As far as I know, there's no case out there that gives trial courts certain formulas to follow or certain findings to make on the record.
Well, we've hit on several of them, haven't we? The need for the evidence is one, the strength of the evidence, the danger of unfair prejudice.
Right, and
there's
there's a plethora of authorities out there on relevant 403 factors. Sometimes courts of appeals consider only some of the factors. Sometimes they consider every single factor listed in opinions. It hasn't been a scientific formula. It's a case-by-case approach.
Sure.
So, and that's and it's hard to really, unless the trial court makes findings and explains its 403 analysis, the best that the Court of Appeals can do is just look through the record to see if the 403 balancing considerations were done. And in this case, there's enough in the record for the Court of Appeals to conduct a 403 analysis, whether it's applying 2 or 3 factors or all of the factors. But it really is a case-by-case approach when you read the opinions on Rule 403.
Was there other evidence that the state could have resorted to in order to demonstrate that he wasn't slow, as he suggested?
That's not apparent in the record, so I don't know.
Which kind of leads me to, I mean, it feels to me that one conclusion one can draw is the state found this super fun evidence, and they were going to use it however they could. And the minute he said, "Well, I just don't understand what's very on," they went, "Aha, it's coming in." And especially in a non-death capital case where there's only one phase, there's not going to be a punishment phase. If he's found guilty, it's just going to come in. So why shouldn't our court just draw the conclusion here that, like Judge Urey sort of intimated that like they didn't even try to find any other evidence of his ability to use language.
The record is silent on that. We don't know that they didn't. It's
well,
silent.
I mean, but the fact that they did not have any other, I mean, this seems like a really long way to get to he understands language. Like, instead of calling his 8th grade teacher to say he understands language, or calling his cousin to say he understands language, instead we go this really long circuitous route to get to the videos.
To be fair, we have 2 videos. One was a group video where his solo segment was only 45 seconds, and only that part was published. The other video, I don't remember off the top of my head, but it might have been maybe 2 minutes, 1 minute and 45 seconds, not that long. And then you had 4 Facebook posts. And they weren't lengthy posts. They were literally a sentence on each page. So the state didn't spend a significant amount of time on them. It was just one issue, his familiarity and comfort with using words, and this evidence was relevant to show that he probably did understand words and was not as dumb as he presented himself
But wouldn't
to be.
his confession have shown the same thing? Or his statement to the police have shown his ability or lack thereof to use language coupled with his testimony at trial? Like, isn't that a much better indicator of his ability to use language than, what may have been very lengthily rehearsed videos?
I mean, it's one piece of evidence. The recorded confession might show how he talks to detectives when he's being interviewed about an offense. The rap videos might show how he talks when he's with his friends or when he's comfortable. Like, they just all show different parts. And then his trial testimony certainly probably presented a different picture to the jury. So this, maybe it was a little redundant, I don't know, but it was still relevant, and relevance is a low bar. And like I said, the evidence wasn't lengthy. We had 2 short videos and 4 Facebook posts out of 1,000. But the bottom line here is that the question that Appellant presents to this court about the unique characteristics of the rap genre were never presented to the trial court. And as this court and if this court were to now consider the merits of Appellant's arguments about the cultural aspects of rap music, its potential to racially impact a jury, this court would essentially be considering an issue that neither of the lower courts has considered. And as this court knows, preservation of error is a systemic requirement on appeal. For that reason, the state asks that this petition for discretionary review be dismissed as improvidently granted. And if this court has no more questions?
I have a question. It's sort of going along the idea of confusing the issue. The appellant's name, his MC handle is Block de Fufu. What is Fufu, and why does it need to be blocked?
That evidence was not developed on the record. I have no idea.
Thank you.
Hey, please, the court. To answer your question, the prosecutor did ask the defendant about the name, and he basically said it's just a name, it's just rap.
Okay.
So, the state seems to think that what I'm arguing here is different than what the trial objection was. The trial attorney specifically said at the end of his standard 403 objection, he stated, this is vilification by rap. And if there is one word that describes my appeal at both the Court of Appeals and here, it's vilification by rap.
Excuse me, let me just ask one question.
Excuse me?
Are you advocating that we adopt a bright line rule that basically prohibits the state from introducing any type of rap music that they can link to the defendant that advocates for any kind of violence?
Actually,
just
I'm
across
asking,
the board?
I'm asking for a broader rule. Anything on artistic impression, which would include rap, that there is a bright line rule, that it has to be directly connected to the evidence in the case.
What if the defendant leaves a false impression on when he testifies? He's a peaceful, law-abiding Boy Scout, and he's creating music that advocates some sort of violence. Why can't the state use that in rebuttal?
Well,
I don't think it's limited to rap. I think there's a recent country and western song that received a lot of national attention about people taking law into their own hands in small towns.
Yeah, try that in a small town.
I'm gonna.
Created quite a stir. So, I mean, how do we adopt such a bright line rule if a defendant opens the door to that type of evidence?
Well, the state is allowed, if he comes in with, it generally comes in at punishment, but if he puts on that he's a law-abiding citizen,
Right.
and then you're saying that you can come in with evidence, that would be different than what's here. The defendant testified he was friendly. I don't think friendly in the rap music, or I don't think it addresses that issue at all.
How would we take away the discretion of the trial court under 403 and create a bright line rule to prohibit that from coming in? Because then you're just taking the judge's discretion away.
Let me see if I can get at it this way. In my brief, I state that the use of rap music as evidence of criminality is just as, excuse me, wrong. Wrong. Rap music as a genre, whatever that word is, often glorifies violence, misogyny, crime, and other messages others find offensive. That's why in this case, the Court of Appeals said that the evidence was a slight nudge, and you're using basically something that's just rife with potential for prejudice as a slight nudge. That's not a fair balance of how evidence should come in. And it's my argument here that the prejudice is way up, and the relevance is, as described by the Court of Appeals, a slight nudge as to helping the government prove a critical issue in the case. I'm suggesting they didn't offer it to prove the evidence of the case. They offered to prove he's a criminal general. She argued on, the prosecutor argued on, in her final closing argument, he's the type of criminal that sneaks around in the night.
Can I ask you a question?
Excuse me?
I'd like to ask you a question
Yes, sir.
about the standard that you'd like us to enact in one of our opinions. So let me start with, are you familiar with, I think she's an actress named Kathy Griffin? Have you heard that name before? There's a sort of iconic picture of her, maybe in a negative, iconic way, holding up the picture, holding up the severed head of a former president. Are you familiar with that at all?
Vaguely. I remember some
Well,
kind
what
of.
I'm wondering is if somebody like Kathy Griffin were accused of murdering that person, would that artistic impression of her that she participated in, of her holding up that person's head, be admissible in the trial against her under your standard?
I think, yes, because it's directly, you said holding up the person, she actually murdered the person she's holding up the head?
Yes.
Yes. If she murdered somebody else, no.
Okay.
Yeah.
I just want to understand how far your standard goes, that's all.
Right. Again, I'm down to 5 seconds, so I can't talk that slow or fast.
Thank you, counsel.
Thank you.
The case is submitted. Call now cause number WR 94-42001, ex parte Willie Mornell Thomas.